Hi everyone, welcome back to my channel. I hope you've enjoyed The Curse of Palmyra Atoll. That was the latest series I've been working on, so I thought I'd dip back into the upcoming trial or trials of Lori Vallow and Chad Daybell. Let's start with the copyright disclaimer and the caveat that this is my opinion on these motions that have been filed. Opinions are not facts, and the viewers are smart enough to figure out that they can form their own opinions. So let's have a look-see at the state's motion to find good cause to continue the trial and to prevent improper severance. Basically, now that Lori is restored back to competency to stand trial, they would like to restore the prior trial date to commence on January 9th, 2023 for both defendants. And they state because on April 11th, 2022, the court entered an order finding the defendant, Lori Vallow Daybell, was fit to proceed, and so the stay had been lifted. And on April 19th, 2022, Lori Vallow was arraigned, and she requested her speedy trial rights. And what the court does is it looks at the law, and it looks at the argument. And it talks about how the right to a speedy trial is guaranteed by the Sixth Amendment to the United States Constitution and Article 1. It also looks at Idaho Code. The state argues that the relevant part of the Idaho Code provides that the court must order the prosecution, essentially the speedy trial, within 6 months, quote, unless good cause to the contrary is shown. Then what they do is they go and they look at different cases to try to determine what that good cause would be. And in other cases, they've used a 4-part balancing test, essentially, to see whether the defendant has been deprived of his speedy trial right. They look at the length of the delay. 2, the reason for the delay. 3, whether the defendant asserted the right to the speedy trial. And 4, the prejudice to the defendant. When considering whether there's a good cause for the delay for the speedy trial, they recognize that it's often inevitable and wholly justifiable to have a delay, but they attach great weight to the considerations for the such things as the state's need for time to collect witnesses, to oppose the pretrial motions, to locate the defendant in the event he or she goes into hiding. Those are just some examples. One could argue having the case stayed because the defendant is put into a mental institution is also a good cause for a delay. Further, the length of the delay is a triggering mechanism. The state argues that the court should find the good cause to continue the trial date as the reason for the delay arises to the level of a legal excuse, and the length of the delay is short in relation to the complexity of the case. And now we're talking a complex death penalty case. They argue that this is even more true in a case of this complexity with voluminous discovery, arranging trial logistics for a different venue, and they added that recently the co-counsel for Lori Daybell has recently been appointed and needs time to digest the status of the case. And finally, most importantly, a brief continuance would also allow both co-defendants to proceed to trial in an efficient manner without any kind of improper severance. The state notes that the court had previously entered a memorandum finding that the joinder of the defendants' cases together was proper. The court's rationale in that memorandum was valid, and that it would be undermining that by allowing one joined co-defendant, Lori, to assert a speedy trial as a method of obtaining improper severance early on in the case. They also go on to note that January 9th, 2023, that trial date is a relatively short date. They note that the U.S. Supreme Court has held that for constitutional purposes, a, quote, delay is not presumptively prejudicial until it approaches a year. And they note, they've done the math here, The difference between what she's requesting and what they're requesting is 2 months and 29 days. That's not a long time. They also add, since there's been a change of venue and the defendant, Lori Vallow, agreed to the venue change and for the court's decision to hold trial in Ada County, and that also this same with Chad, that they had asked for the change in venue, it's even more important to keep the trials together. Just to put on my fortune teller's hat here, looking at this motion and the law in support of it, I do believe that the state will get what they want. They will get the date they want, barring something happening outside of the court regarding Lori's mental state. And looking at the cause of delays, whether it's something on the fault of the state or the part of the defendant, they note that the need for restoration efforts and the length required for that is directly attributed to the actions of the defendants. That would be Lori Vallow Daybell, and her being in the institution is not the state's fault. And the final factor that the court looks at is the prejudice to the defendant. You really do not want to ever prejudice the defendant. And they cite the history of this case, and they mention that the length of the pretrial incarceration at the mental hospital was at the defendant's request, and that the commitment to the mental health facility was necessary to address her competency and other mental health or medical concerns. That factor even takes into consideration the anxiety the accused might have, being stressed when facing charges for murder, and whether the speedy trial would affect that. But they say that indeed anxiety by itself is generally insufficient to support a claim of a speedy trial violation, because usually they're stressed or anxious anyway being on trial, especially in a death penalty case. So the state sums it up that weighing the limited prejudice suffered by Lori at this point, her assertion of speedy trial rights arraignment against the relatively short length of the delay suggested here, and considering the complexity of the case and the valid reasons to delay the trial, the court can properly find good cause to continue the joint trial to the date of January 9th, 2023. I do believe they will get exactly what they want with this motion. And then in the certificate, they add this little sweetheart in the end, that the notice of intent to seek the death penalty was served for Lori. It was served on James Archibald and John Thomas. So yeah, that's where we are now in this case. They did file a response. I'll go over that really quickly. The response is in regard to the state's motion to continue. So here it is. So comes now defendant Lori Vallow Daybell, and they note that she's been incarcerated and hospitalized for over 2 years since her arrest on February 20th, 2020. They also note in number 2 that she has instructed her attorneys not to file a request for a separate trial. She does not want the trials severed. They note how she was in custody for over 2 years, and that she was just arraigned on April 19th, 22, essentially when she got out of the hospital, and that she had previously hired private counsel, but then she was found to be indigent. So, what's kind of like building up to like, hey, we've got 2 new attorneys on the case. If I had to read between the lines between what the clients want and what they want, I kind of get the impression the attorneys don't mind waiting a couple extra months, that the defendant wants the speedy trial, but then by that same token, she doesn't want to be severed. This is kind of interesting. Under 5, they said she has met several times with her defense team, currently consisting of lead counsel, co-counsel, a mitigation specialist, and an investigator. She understands that her defense team is spending a considerable amount of time going through the mountain of discovery in this case in order to get ready for trial. She understands that the defense team is in the process of identifying and interviewing witnesses for the trial and the potential sentencing if there's a conviction. She understands the heightened scrutiny in a potential death penalty case. So that's a whole lot saying, a mountain of evidence. 6. And this one is the one that gets everybody's head scratching. Lori Vallow Daybell's mental health is extremely complex and fragile, and she has the potential to be hospitalized again in the near future. Okay. They note that none of the experts employed by the court or the state of Idaho Department of Health and Welfare claim that she's malingering or making up her mental illness. So, what are they saying here? It's almost like, oh my gosh, she's really fragile right now. She's competent right now. Maybe we need to go right now because in 2 weeks, 2 months, she might not be competent. It's kind of an odd, it's an odd little motion, isn't it? And 7, they say that the defendant understands her rights to a speedy trial, does not want to waive those rights, and if the court moves her trial from October 11th, 2022 to January 9th, 2023, she understands that this will give her defense team more time to get ready. Again, in my opinion, the defense team needs more time probably to get ready, and Lori's just saying, oh, I want my speedy trial, but then I still want to be with Chad. So, in my opinion, they're going to get the trial date of January 9th, 2023, barring something else out of court happening. So, there's my opinion, guys. Let's get ready. Let's get ready to watch this, because you know what? Before we blink, January 9th, 2023 will be here. And I hope you're here with me. If you like this, push that like button. Subscribe for more. I'll cover this trial. And I hope that you're having an excellent day. I hope you're staying safe. And without further ado, take care.